The Sarbanes Oxley Act of 2002, a presentation prepared by Heather Miller. Encouragement of ethical conduct within an organization is of high importance both in terms of following the law as well as laying a foundation for good business practices. This fact may seem obvious to those of us who find it comes easy to make decisions and take action based upon the fundamental understanding of what is right and what is wrong. However, it is actually quite common for people to make decisions that they are aware are unethical, but follow through with anyways, because they think to themselves, it is really no big deal if I bend the rules just this one time. The problem in such cases is that this one time often snowballs into continued unethical behavior that becomes worse the longer it goes undetected. In 2001, it became public that numerous major companies had been allowing questionable accounting practices for years that skewed financial earnings in the company's favor. These events made it quite clear that a stronger set of laws was needed in order to rein in this kind of unethical behavior. What resulted from these events was the Sarbanes Oxley Act of 2002, which is the main focus of my presentation today. The purpose of this presentation is to provide some perspective on how such unethical actions could emerge in a business, and how these actions often lead to the need for government intervention through federal laws, using the Sarbanes-Oxley Act of 2002 as a basis for example. In order to address these issues today, I will provide two summaries of real-world examples where unethical conduct led to the need for stronger laws, go into depth regarding the details of the Sarbanes-Oxley Act of 2002 and how each of its sections address areas of business that were in need of reform, and discuss the role of the Securities and Exchange Commission in enforcing the Sarbanes-Oxley Act of 2002. In the late 1990s, the Enron Corporation transitioned its business from operating natural gas pipelines to focusing on energy concerns. In the process of this transition, aggressive accounting practices were undertaken by their accounting firm, Arthur Andersen LLP, to accompany the quickly growing corporation. At the time of the transition and thereafter, Arthur Andersen LLP provided financial statement preparation and filing and internal auditing services, in addition to consulting services for the Enron Corporation. Starting in 2000, Enron's financial stability began to weaken, and in 2001, it became publicly known that Enron was undergoing some financial difficulties. Aware that an SEC investigation would soon follow the public release of the third quarter earnings of 2001, which revealed a charge against earnings of $1.01 billion, Arthur Andersen LLP instructed its employees to destroy documents pursuant to its document retention policy. Such actions constituted obstruction of justice, which at the time of the actions was against the law. Sarbanes-Oxley sought to respond to these actions by increasing the penalties for existing obstruction of justice offenses. Additionally, new laws were created via the Sarbanes-Oxley Act, including restrictions specifying a retention period of 5 years for audit records after the completion of a corporate audit, as well as a specific law against destroying, altering, or falsifying records relevant to potential future federal investigations or bankruptcy. Sharon Watkins, a vice president of Enron, played a key part in bringing attention to Enron's bad financial practices after taking the initiative to bring the unethical accounting practices to light. Shortly after Jeff Skilling chose to leave the company after only 6 months working for Enron in the position of CEO, Sharon Watkins decided to indicate her concern over the faulty accounting practices that were taking place during a meeting with Ken Lay, chairman of Enron. Documents subpoenaed upon SEC investigation included an email dated only 2 days after this meeting. The email was between Ken Lay and Enron's attorneys with the subject line, "Confidential Employee Matter," in which the attorney made the following remarks. Per your request, the following are some thoughts on how to manage the case with the employee who made the sensitive report. You ask that I include this communication a summary of the possible risks associated with discharging or constructively discharging employees who report allegations of improper accounting practices. This evidence made it clear that stronger laws were needed in order to protect whistleblowers, such as Watkins, from retaliatory actions. From Watkins' point of view, she was merely providing a warning to the corporation's chairman of the likelihood of impending litigation and the need to correct it before it got any worse. However, her warnings were not appreciated by the chairman, who, along with Enron's CFO and many other employees, felt that such warnings were only a means to create waves in a system that, while unethical, was working in favor for the company at the time. The subsequent passage of the Sarbanes Oxley Act was key in establishing a more positive view of whistleblowers, while also providing them with the legal incentive to come forward when becoming aware of any information relating to the commission or possible commission of a federal offense. The previous examples are merely glimpses into the types of unethical business conduct that help to bring attention to the need for government intervention in the regulation of corporate accounting practices. As a result of these and many other schemes of corporate accounting fraud that came to light just prior to 2002, Congress responded by creating the Sarbanes-Oxley Act as a means to intercept any future wrongdoings by accounting firms, as well as discouraging CEOs from turning a blind eye to poor financial reporting practices. Without the provisions and laws put into place by Sarbanes-Oxley in 2002, investors would be left to make a bet on whether or not the corporation they are investing in is being honest in their financial reporting. While SOX is not necessarily all-encompassing in halting accounting fraud, it has certainly helped in encouraging a higher standard of what is expected for honest and quality financial reporting measures. The Sarbanes-Oxley Act of 2002, often referred to as SOX, is a federal law that was enacted on July 30th, 2002 in response to poor accounting practices by publicly traded corporations, which caused shareholders to be deceived as to the true financial well-being of the corporations in which they were investing. Due to the fact that the law was enacted in response to public corporate scandals that affected shareholder wealth, it does not apply to privately held companies. The Act addresses such issues as assessment of internal controls, measures of corporate governance, the need for independent auditors, financial statement accuracy, and the need for enhanced financial disclosure requirements. The Sarbanes-Oxley Act of 2002 consists of 11 titles, each of which contain a various number of sections. Each of the titles focus on specific areas which are aimed at addressing the inconsistencies found among the financial reporting requirements of publicly held companies. The following sections will provide a brief summary of each of the titles, as well as a review of the purpose behind each title. Title 1 under Sarbanes-Oxley consists of 9 sections and established the Public Company Accounting Oversight Board, or PCAOB. Prior to the passage of SOX, the accounting industry largely regulated itself. The PCAOB addressed the need for the independent oversight of a company's external auditors to ensure greater accuracy in financial statements. The PCAOB is largely responsible for establishing standards of ethics and practice to be followed in accounting and auditing. Title 2 under Sarbanes-Oxley consists of 9 sections and establishes the requirements to fulfill in order to maintain external auditor independence. In order to understand the significance of the laws under Title 2, it is important to provide a summarized history of the role of the accounting firm as it has evolved over the past 40 years. In the 1960s, the main role of accounting firms in relation to public corporations was to perform auditing of the company's financial statements. However, as the age of the computers came into view, the large accounting firm Arthur Andersen correctly predicted that the real income would come from consulting activities. Specifically, Arthur Andersen became an expert in the use of computers in order to improve business performance, and then passed on that information for a fee. This was the essence of the start of consulting within the field of accounting. The problem with this business model developed when such consulting activities presented a conflict of interest toward an accounting firm's auditing responsibilities. Since the majority of most accounting firms' profit was now coming from consulting income rather than from auditing income, those firms were more inclined to look the other way when auditing a company's financial statements that created obvious gross financial misstatements of fact. In order to address the increasing issue of fraudulent financial reporting, the passage of Sarbanes Oxley sought to increase the independence of auditors by disallowing auditors of public firms from performing non-audit related consulting activities for the same firm. Title III contains 8 sections and addresses the need for senior executives to take individual responsibility for the accuracy and completeness of their company's financial statements. Under Title III of SOX, the CEO and CFO of any publicly traded company is required to certify that the financial reports published by the company are without any material misstatements of fact or omissions in regards to the financial well-being of the company. Signing officers are also responsible for establishing internal controls, as well as the duty to maintain and evaluate the effectiveness of those controls. In addition, the signing officers have a duty to disclose to the audit committee any fraud among the employees or officers involved with the firm's internal records. Title IV contains 9 sections and addresses the need for enhanced disclosures to accompany financial statements and reports. Some examples of financial misconduct prior to the passage of the SOX Act included movement of large amounts of debt off the books, the use of special purpose entities in order to manipulate the true financial status of a company, and the use of pro forma for financial statements, which are statements that presented a much more positive financial picture of the company than the generally accepted accounting principle compliant financial statements would. After uncovering that these questionable methods were being used by many companies to enhance how their financial reports appeared to the public, SOX instilled requirements for enhanced financial disclosures. Title V contains 1 section and addresses the need to restore shareholder confidence in the reporting of securities analysts and establishes a code of conduct for securities analysts. This code of conduct includes a requirement to disclose known conflicts of interest. The role of a security analyst is to make buy-sell recommendations regarding company stocks and bonds. The role of an investment banker is to help provide loans to companies as well as assist in handling acquisitions and mergers. Should a company use an analyst that also provides their investment banking services, this allows for what may appear to be a conflict of interest. Title V of SOX thus addresses this concern by requiring public companies to disclose such possible conflicts of interest to shareholders. Title VI contains 4 sections and addresses the need for defined practices for securities analysts in order to restore investor confidence. It also establishes the SEC's authority to bar securities brokers, dealers, or advisors from practice under specific conditions of misconduct. Although the SEC's authority to discipline accountants has been questioned in the past, Title VI of SOX establishes clear authority as being delegated to the SEC to perform such action. Title VII contains 5 sections and mandates various studies to be performed by the Comptroller General and the SEC and the timely reporting of their findings. Title VII acknowledges that the SOX Act was passed through legislation relatively quickly in the wake of corporate scandal. Therefore, Congress left many matters open for further study. A few of the major concerns are related to the lack of competition among accounting firms, questionable practices among credit rating agencies, reinstatement of the private cause of action for aiding and abetting, concern over whether SOX provisions enacted in 2001 were inadequate, and determination of whether investment banks aided in manipulating the earnings of public companies. Title VIII contains 7 sections that describe particular criminal penalties for the manipulation, destruction, or alteration of financial records. This section also addresses protections for whistleblowers. Prior to the passage of SOX, as pointed out by author Kathleen F. Brickey, whistleblowers have historically been at risk of being labeled troublemakers. Apart from the very real risk of being shunned by coworkers as disloyal tattletales, whistleblowers are often demoted, fired, or even blackballed by an entire industry. SOX sought to reverse this negative image for whistleblowers by providing them with legal protection, which provides civil remedies in cases of retaliation, as well as criminal penalties against anyone who takes retaliatory action against anyone who provides information regarding a crime to federal law officials. Title IX contains 6 sections and addresses the need to increase criminal penalties for white-collar crimes and conspiracies. It also contains stronger recommendations for sentencing guidelines. Title IX most notably specifies the failure to certify a firm's financial statements as a criminal offense. This provision aims to ensure that CEOs and CFOs do not just blindly sign off on financial statements that their auditors approve, yet take personal responsibility for ensuring that the financial statements of the company that are filed with the SEC are accurately portraying the financial status of the company. Title X contains 1 section which states that the company CEO must be the person who signs the company's corporate tax return. This provision was added as a response to the Enron scandal, and it expresses the sense of the Senate that CEOs should sign corporate income tax returns. Title XI contains 7 sections and specifically names corporate fraud and records tampering as criminal offenses and assigns specific penalties for those offenses. After the Arthur Andersen and Enron scandals, Congress became more concerned with acts of obstruction of justice. Their response was the provision set by Title XI of SOX under Section 1102 that criminally punishes anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. In addition, due to the fact that this is often difficult to determine who is materially involved in fraudulent activities that are being investigated by the SEC, Section 1103 authorizes the SEC to temporarily freeze the funds of a company under investigation. Furthermore, Section 1105 grants the SEC authority to permanently ban certain individuals from serving as officers or directors of public companies. In addition to containing 11 titles, each containing a various number of sections, Sarbanes-Oxley Act obliges the Securities and Exchange Commission to implement rulings on requirements needed to enforce compliance with SOX. Before going public, a company must file documents, which include their financial statements, with the SEC. Theoretically, through this process, shareholders feel reassured in that the SEC makes certain that the financial statements of publicly traded companies are thoroughly audited to maintain accuracy and credibility of publicly traded companies. One problem encountered by this scheme is that at the time of the major corporate scandals, such as those involving Arthur Andersen and Enron, were unraveling, it was made clear that the SEC was greatly underfunded and understaffed for the quantity of duties for which they were expected to perform. Title VI of the Sarbanes-Oxley Act addressed the need to increase funding to the SEC so that this agency can adequately address its responsibilities. Funding increased between the fiscal years 2002 and 2003, and the SEC has hired more staff since the passage of SOX. In turn, in early 2002, the SEC was able to examine the annual reports of the largest American companies for the first time in years. While the increased funding is certainly not all-encompassing in addressing the needs of the SEC, it is important to keep in mind that without the addition of SOX, the SEC would likely have not received any additional funding, which in turn would likely have led to additional undetected financial scandals since that time. I chose the Sarbanes Oxley Act of 2002 as my research topic for this class because I work in the field of accounting, and Sarbanes Oxley has led to the reform of the accounting industry practices since 2002. Therefore, I was interested in learning more about it. This topic applies to what was learned in our class in relation to how ethical conduct is important in business, not only for the benefit of the company, but for the benefit of society as a whole. While many classes and business seminars may address the topic of ethics and how they relate to proper business practices, it is often overlooked that laws such as the Sarbanes-Oxley Act of 2002 help to reinforce the basic notion that if an unethical action is also made to be illegal, there is less of a likelihood that unethical decisions will be followed through with in the first place. The main thing I learned from researching this topic is, prior to Sarbanes-Oxley, the accounting industry was largely left to regulate itself. While it is not always a good thing for the government to intervene, once it became clear that leaving accounting standards so open to interpretation could become harmful to shareholders, the issue became a public concern. The Sarbanes-Oxley Act is important to the legal and business world because it forces companies to become more transparent in their financial reporting practices so that the public can be made more aware of how well a company truly is doing financially. Based on that premise, I was able to reach the conclusion that without the enactment of Sarbanes-Oxley, it is quite possible that the unethical actions, such as those that took place at Arthur Andersen LLP and Enron Corporation, would still be taking place today, leaving shareholders in the dark in regards to what they were truly putting their investments towards.